Hey everybody, it's me, Matt Esquire, here with an update on everyone's favorite court case, Gibson versus Armadillo DBA Dean Guitars. Yeah, it's the Gibson versus Dean case rearing its ugly head once again. The reason it's rearing its ugly head is because on Halloween this year, trick or treat, Dean has to appear in court and explain why it should not be held in contempt of court for willfully violating the jury's verdict. What had happened back in, I believe it was May of this year, after the jury verdict, the CEO at the time, Evan Rubinstein, gave an interview to, I believe it was Guitar World magazine, at which time he gave quite possibly the worst statement that any officer can say on behalf of a company that has just lost a court case. He was asked, with the jury ruling that Gibson's trademarks are not generic, will Dean drop any models from its product line? And to that, Mr. Rubenstein responded, quote, "We have no plans to drop the Dean V and Z guitars, nor the Dean Evo headstock, as the jury found no trademark liability on any of those. That said, the case is by no means over." That is a really stupid thing to say. The CEO was saying to the world, including to Gibson and the court, that it was not going to comply with court orders. And the one thing that courts like is people obeying its orders. So what Gibson did is what any other company would do in that situation. They went on down to the courthouse and they filed a motion to hold Dean in civil contempt. I had actually gone on to Pacer and tried to download a lot of it. Here's the thing. Most of it is under seal. However, just about a week ago, a surreply to the motion was filed. It wasn't under seal. It pretty much laid out the meat of this argument. This document is 14 pages. It sounds like a heavy read. It isn't. It's actually, page 1 is a title page. Page 2 is a page full of court citations. Page 3 is half taken up by, a preamble. Most of the pages are actually just pictures. It is a picture book. You got Mr. Rubenstein's words, and if you look at their website, you'll see they are still in defiance of this order. Now, Dean had tried to say, well, they don't have time to comply with this. They have got to retool this and that. Please give us more time. But that's really not a very good argument. One of the things that courts like to look for, if there's not full compliance, what they will look for is something called substantial compliance. Now, substantial compliance could mean paying part of a fine or taking concrete steps to comply. But here's the thing. There wasn't even that in this case. They said they don't have time to comply, but one of the things that Gibson lays out here is they say, go look at Dean's website. They're still selling the V. They're still selling the Z. And if I'm a judge, I'm just going to say, cut through the crap, counselor. Why are those still on your website? Can't you take those off your website at the very least? And if I'm Dean's lawyer, I'm going to have to start tap dancing because there is no good answer to that. The only answer is, I really don't know at this time, Your Honor, at which point you've just lost. The fact that there's not even them taking it off of the website, coupled with Rubenstein's statement, it does not look good. Just as a recap, originally, the original verdict was actually not terrible to Dean. Dean had to pay $4,000 in fines and prospectively, going forward, had to stop selling the infringing designs. Basically, guys, stop breaking the law, okay? We're going to turn a blind eye against those past transgressions because Gibson did nothing. But now they're doing something, so stop. Then Gibson went back and said, you know what? They're still sticking their thumb right in the court's eye. And at that point, things started to turn badly for Dean. For starters, Dean got ordered to pay Gibson's legal fees. So that meant that in additional $4,000, there was several $100,000 worth of legal fees that now Dean had to cough up. It keeps getting worse from there. Evan Rubinstein was then the CEO. It's not like Evan Rubinstein quit. In fact, it's not even like Evan Rubinstein was pushed out. He was actually, according to several articles, forced out by his mother, who now is serving as the CEO. He's alleged to have embezzled $420,000 from the company. So if that's true, $420,000 missing from Dean's coffers, on top of several $100,000 more of Dean money that's going to go straight to Gibson. And on top of that, there's going to be a lot of legal fees involved with any case to recoup the $420,000 from Evan, as well as any future costs that Gibson needs. One of the things that they're saying on why they need a contempt order is they're saying, look, they've already shown that they're not going to comply. So right now, we need to monitor them. We have to sit and watch them like a hawk because they're not going to do it. They're not going to comply unless someone holds them in contempt. One of the things they say is that they're going to need to contact the registrar for the domain for deanguitars.com. And honestly, I wouldn't be surprised if Gibson tries to seize that. It's really going after a lot. Dean did stop selling the Grand Sport guitar, did stop using Hummingbird, but once again, no one cared about those. People cared about the V and the Z, the Explorer design. Because of that, they need this order. This is really, it's not the final nail in the coffin for Dean, not by any means. Now, one of the things that should be noted that also is on there is what's called a notice of appeal. When you're going to appeal, you need to let the court and the other side know you're going to appeal this, and that has been filed. And that brings me to another thing that Gibson could ask for, and that's a rather fancy word. It's known as a supersetious bond. And what a supersetious bond is, put up or shut up. You basically have to put up all of the money that you owe on the judgment, and maybe then some. It might be twice the amount, and it goes into an escrow account and held by the court. And that way, if you lose, the other side doesn't need to chase you for that money. They've already got the money. They take it out of that escrow. I could very well see a supersetious bond having to be required to be posted by Dean for its appeal. Their course of conduct is, to use another legal term, willful and what's called contumacious, basically full of contempt. It will be interesting to hear what happens at the Monday hearing, because I honestly don't think it's going to go well for Dean. That statement by Rubenstein was very ill-conceived. It was not a wise choice, and it's going to come back to harm Dean. This is probably going to signal the beginning of the end for Dean guitars. They don't have any other designs out there to speak of. That's not to say that Gibson doesn't overreach. They do. But it's honest overreaching that everyone does. You know, there is a lot of chest thumping. The top of page 7, they say appropriate sanctions may include a coercive daily fine, a compensatory fine, or coercive incarceration. No one is putting anyone in prison for this case. That's not even happening. They are asking for reasonable costs and fees, and they're going to get those. They undoubtedly already have a statement already prepared showing their reasonable costs and fees, and the judge is going to sign off on it. This is just really Dean shooting themselves in the foot. So we'll continue to keep you posted on that. Should be fun. And as always, like and subscribe. Feel free to post your opinions, any other questions you have. We are going to try to keep posting viewer comments videos. We found that to be fun. But in the meantime, less fiddling, more playing.